I welcome you all to Indian Review of International Arbitration, distinguished lecture on international arbitration by none other than Mr. Kevin Kim, who is a senior partner at Peter and Kim. He didn't he does not require an introduction, but it's my duty to welcome him. So he is presently a senior partner, and previously he was a senior partner at By Kim and Lee LLC. In past 3 decades, in various roles he has worked. He has been the co-founder and head of international arbitration practice and head of the domestic and international disputes group of the law firms he has worked with. He has acted as counsel, presiding arbitrator, co arbitrator, sole arbitrator in more than 300 cases of international arbitrations under various international arbitral institutions. He is involved in plethora of investment and commercial arbitrations. Amongst other positions, Kevin is also an advisory board member of the reputed International Council for Commercial Arbitration. He is the chairman of the Korean Commercial Arbitration Board, International Arbitration Committee, and an adjunct professor at the Seoul National University Law School. In the past, he has served as the vice president, which is a coveted position in the sphere of international arbitration, of the ICC International Court of Arbitration. He has served as Secretary General of ICCA, member of the LCIA Court, Vice Chair of the IB Arbitration Committee, and many more. He is constantly recognized as a leader in Who's Who Legal. So, 2020 Who's Who Legal says about him that Kevin Kim, is a key figure in the Korean arbitration market who has built a strong network of arbitrators and practitioners and is widely considered a statesman in the market. It's no exaggeration. It's no exaggeration. Whatever interaction I have with him, what I have understood, he is not just a market leader. He is also a great human being, and his journey is the journey of Korean arbitration law. So that's why today we have him here to speak on the issue of how arbitration has developed in the Korea and what lessons can be learned by emerging arbitral jurisdictions. In my previous discussion with Kevin, he informed me that in terms of volume, Korea is one of the biggest market in Asia of arbitration. So the kind of attention we give while sitting in India to UK, America, or other jurisdiction might be exaggerated because in our own Asia, we have leaders like Kevin Kim, uh, who through their 3 decades of practice is taking their jurisdiction forward, and the jurisdiction itself is marching forward in terms of arbitration. So, with this small introductory note, I welcome you, Kevin. It's wonderful to host you, and on behalf of MNLU Mumbai, we look forward to have a wonderful session from you. Our Honorable Vice Chancellor has joined us, but as I said, he's stuck in some traffic. He will join us in between, and probably at the opportune moment, we would look forward to hear him as well from him. Over to you, Kevin.
Thank you very much, Professor Bayan. Very good day to everyone attending this event. It is my distinct honor and privilege to speak at the event on very interesting topic about development of arbitration in Korea and lessons from emerging arbitral regimes. Maybe I can share slide. So can you see my slide? Okay. So I understand that I've been around 1 hour to speak on the topic. And it is a big responsibility for me to ensure that the audience will be kept entertained. So I'll deliver my speech. I will use the PowerPoint presentation only as a visual aid, and I'll project a few images that I hope will give you some visual insight into Korea. I aim to finish my speech earlier so that we have some time for question and answer that audience may have. So I'll begin an anecdote about this picture on the screen. That is from a time when the arbitration is almost non-existent in Korea. It is a picture of my siblings and me on the fair ride. I'm the tiniest one there. I remember that it was, I was about 7 years old. It was 1969. You see the Korean words on the plane. That is the English translation of the phrase is the New York bound. So this is the first plane I was on board. In those days, living in the West was almost aspirational. So be it in development, industrialization, or the technology, the West was the gold standard. For several years, even up to a few decades back, the idea of international arbitration did not catch up in Korea. There are various reasons that could be attributed to late entry of international arbitration into Korea. First, until a few decades back, international business transactions were not common. Not many international agreements were entered into, and as a result of not many international arbitration agreements was signed at the first place. Second, there was a perception that common law dominated international arbitration, and Korea being a civil law country, there was a hesitancy to embrace international arbitration. Third, the concept of international arbitration was considered foreign, where the West dominated the international arbitration landscape. Fourth, and this is true even to date, the domestic courts are very efficient to handle domestic dispute. Even international dispute, the Korean courts are very efficient. The rank as #1 in the World Bank record to shows that the enforcement of a commercial contract, Korean courts rank as #1 in the world. If I had to pick one word to describe Korea's rise in international arbitration and the current state, that word would be vivid. Although we like the expression like dynamics. Both Korea parties and council has become very active in international arbitration landscape. The kind of arbitration matters arising out of Korea has been mostly high value and specialized. Such cases are so large that many a time they are more sophisticated from the kinds of matters that are dealt by older or more established arbitral jurisdictions. So the natural question that arises is what led to phenomenal growth of international arbitration in Korea? Instantly, the growth came at the heel of Asian financial crisis toward the end of 1990s. Exactly speaking, it was started the fall of 1997. The graph on the screen shows that how bad the financial crisis affected Korea in late 1990s. What was also visible in the graph is that the subsequent Korean recovery. As Korean economy came at the verge of the collapse in 1990s, the IMF undertook its largest bailout ever. One of the terms of the bailout required most corporations and the corporations to be disposed non-core assets, other companies. This resulted in rapid and large-scale foreign direct investments in Korea. International arbitration clauses were inserted in most such foreign direct investment. These clauses led to initial several high-value and complex disputes, resulting into final words. As a result of this process, arbitration as means to resolve dispute standard started becoming a common practice. So after economic crisis, the Korean economy grew rapidly. This led to formation and strengthening of some of the largest global businesses. You may have heard about the words "jebol" in Korean. That means conglomerate. It's the big companies have a group of companies. This group of companies was big even that time, but they became bigger as global player in the international market. So once the jebol started investing across the globe, the industry-specific disputes also saw an increase. So this led to Korean arbitration practitioners gain industry-specific expertise. Once the Korean businesses saw the advantage of international arbitral world, there was no looking back. So Korean parties soon became active users of institutional rules such as ICC, LCIA, CR, HKIAC, and others. So in today's date, even though Korea is the much smaller in size compared to China and Japan, actually Korea is surrounded by all big countries. You can tell Russia, China, Japan is around us. And then also if you just treat Pacific Ocean as US, actually we are surrounded by all big countries. So we always think that our country is very small, but actually it is quite small compared to China and Japan. The size of economy is China and Japan is 4 times bigger than Korea. But in the arbitration field, you see from the record that this is ICC statistics for about 10 years a period, what happens here. But if you just take the statistics between 1998 to 2008, so you should 10 years after this financial crisis, ICC witnesses 442 Japanese parties and 499 Chinese parties from mainland China. But the same period, 665 Korean parties participate in ICC arbitrations. So Their economy is 4 times bigger than Korean economy. And Korean economy have 665 Korean parties during the period. So much more than China and Japan. That is quite phenomenal. And between 1996 to 2014, the Koreans own arbitral institutions, the KCAB, Korean Commercial Arbitration Board. KCAB administered a total of 10,171 arbitration cases that include 8,837 domestic cases and 1,334 international cases. I know that this number is relatively small, very small to Indian numbers, but again, our population and the economy is much smaller, but actually case we handle is all serious, very significant amount of dispute. So more than 1,300 international arbitration cases experience in the KCAB means a lot in development of arbitration in Korea. So earlier, most Korean arbitrations was handled by Western law firms. I would say international law firms. We call the international law firms, mostly from UK or US. As the demand for arbitration grew, there was need felt to cater to regional clients, including Koreans and Japanese. So several Korean lawyers, especially those who were trained in the West, returned to Korea to build robust international arbitration practice. And the other thing is actually Korean law firms sending lawyers to abroad after normally 5 or 6 years experience. In my case, I spent 5 years as a Korean lawyer during the corporate work and litigation, and I went to Harvard Law School for LLM. And after that, I practiced in New York and London. So almost 2 years time, and then came back to Korea to this international arbitration. So many of my colleagues have same background. Then we also have many American lawyers who were trained in America and came to Korea to work together with us. And now we have lawyers from India, Pakistan, and Singapore. We have lawyers from Australia, France, Germany, all different countries. So we all work together in Korea. So the inherent advantage they had was the understanding of Korean culture, and then they understand the Asian things. So the Korean lawyers continue building their capacities, especially through counseling with experienced international firms, mostly from UK or US. So we have many cases with co-counsel with the international law firms, and we learned their technology, their know-how, how they handle the case. So with time, the Korean lawyers have understand how we deal with international arbitration, and we became familiar with the international arbitration, and particularly best practice of international arbitration, started adopting those practices in our style of handling international arbitrations. So we also started getting involved in the more advocacy as we became comfortable with international practices. So Korean client also became more comfortable with Korean lawyers because of cultural or linguistic complexities. So gradually, some of Korean firms were doing their own advocacy. Additionally, they were to also manage cases through their complete life cycles. So as of today, there are practitioners not only representing Korean parties in international arbitration, but also global parties in international arbitration that has little or no link with Korea. Since the opening of a legal market for foreign firms, the foreign firms have also started setting up their arbitration practices in Korea. So in the last 20 years, the market has come to a long way from its infancy to adolescence. So I think it has matured fully. It still has a large scope to grow further in very advanced market. Okay. Now I briefly delve into how in the past two decades, the arbitration practice grew from strength to strength. One of the key factors has been knowledge sharing. The most established Korean practitioners took it upon themselves to promote the international best practice in the local legal community. The first generation of the arbitration practitioners in Korea, to which I belong, had the first movers advantage. And we knew that to keep the arbitration story of the Korea strong, there was a need to prepare new generation of lawyers so that they are at par with their counterpart across the globe. The Korean firms also started hiring international practitioners to bring in diverse set of practitioners. The input from foreign lawyers has aided in making Korean international arbitration landscape sophisticated and advanced. As of today, there are several international attorneys from across the globe who are working in various Korean firms and practicing international arbitrations. So if you see that Korean law firms, a particular arbitration practice group, you cannot tell which qualification that particular lawyers have or the background. We don't care about qualification. We don't care about the background or nationality, race, women and men. It doesn't matter. We just work together as one team, and whoever is good, they take the lead in the team. So they are adding value to Korean arbitration landscape with different skills, some of which include language, legal background, and advocacy. At the same time, they are also getting exposed to the K-way of practicing arbitration in international arbitration. So as accumulation of these factors, we can see Korean law firms feature most global rankings in international arbitration practices. So among 100 law firms listed in GAR 100, you can find 6 Korean law firms there. So actually our firm, Pitt and Kim, our name is on, you can find in Switzerland, but actually our Korean side is bigger than the Swiss side. We are quite even numbers, and we have a bit more people in Korea. So it just put our firms together with the other Korean law firms. We have at least 6 Korean law firms among 100, and in addition to 6 law firms, as many international law firms also quite active in the Korean market. The success of Korean story of international arbitration could not have been possible without active government support. When the Korean government saw that effort of legal community was yielding result, it further aided by providing crucial support. That support has been instrumental in enhancing Korea's reputation, a trustworthy and attractive seat for arbitration. I personally involved in persuading Korean government interested in arbitration, and then they committed to the international arbitration. It was actually, it's very lucky, for Korea, because at the time we tried to promote international arbitration. We had huge claim from a international fund against Korean government. So that the case actually lasted for like 8 years. The Korean government naturally interested in international arbitration. International arbitration is quite important matter. So we successfully persuade government to make a separate law, so-called Arbitration Industry Promotion Act. That is a special act to allow the Korean government make a financial support to arbitration industry. So you see the picture here, the Seoul IDRC as its arbitration facility that was funded by the Korean government. So Korea was pioneer among the East Asian countries to adopt model law in 1999. So we are other than Hong Kong and Singapore, we are the first country adopted UNCITRAL model law in 1999. And not only that, but it has also kept updating its arbitration law when it's required. So in recent times, it was updated to incorporate some of 2006 revisions of the model law that happens 2016. So additionally, Korean judiciary has been regularly training judges. This helped the international arbitration landscape as courts are supportive of arbitration process. So far, Korean courts have a clean record. So meaning that there is no single international arbitral award vacated or rejected to the enforcement. No single case. There is one, recently there was 2 cases where the local court, the district court, refused to enforce, and that was appealed. And then Supreme Court say, you must respect the arbitral word, even though there is some issues with there. So we still maintain the perfect record of enforcement for an arbitral word in Korea. And the government and other international organizations such as Singapore International Arbitration Center has assisted setting up these high technology and convenient hearing contents. And then together with that, the court and the government and this international effort putting together the Korea as very stable arbitration law and practice. Other ancillary services has also taken shape in Korea, including translation and transcription service. And what has been instrumental in helping international arbitration in Korea is the Korea status as global city. Seoul is very well connected, and almost every capital city around the world. And Korea has a reputation of neutral country that makes an attractive destination to position itself as arbitration seat and venue. And recently, you see many arbitration conducted virtually. So this is a quite interesting development here. Of course, our internet speed is world best. Our internet speed is about 200 times faster than other countries. In addition to that, this COVID-19 situation the Korea is quite unique because we are allowed it to work in office. We heavily regulated in dinner places or other social gatherings, but working in office, we have no restriction. So we can work together within the office. So many international councils coming to Korea to work together in Korean office, virtually connected to the tribunal. So I see our co-counsels came to Korea. We work together in our office, and then the opposing party also get together in the different Korean law firms office and work together from that location. And then arbitration tribunal is sitting in the foreign jurisdictions. That is kind of new developments in the COVID-19 situation. So over the years, Korea Commercial Arbitration Board, otherwise known as KCAB, has come up the official arbitration institution of Korea. It enjoys support not only the government, but also local and international firms and institutions. So as I explained before, they maintain good case record and they handled case quite well in practice. In particular, KCAB established KCAB International in 2018, a separate body, so within the same umbrella. So it's very similar to ICDR and AAA. So this is a separate people to support international parties in the KCAB arbitration. So KCAB now have a separate committee, International Arbitration Committee, which I'm chairing, have lots of practitioners from all around the world to give advice and initiative. The KCAB International become real international. So with success of KCAB and KCAB International, next progression has been toward, we call the KCAB Next. So like other initiatives globally to promote international arbitration, among the new entrant to the arbitration into different regions of the world, KCAB Next aim to induct Korean practitioners into international arbitration world. So that is the investment for the future, I would say. So in the past, there's another new, it's not recent development, it's a kind of interesting things that to you might be, there is agreement between North Korea and South Korea about arbitration. So meaning that there is any dispute between North Korean companies or South Korean companies, the both governments have the agreement that such a dispute will be resolved by arbitration. We cannot call international arbitration because we have political issue, but whether called domestic or international, we have the agreement that dispute will be resolved by arbitration. So that is the specifically called Agreement on Procedure of a Commercial Dispute Resolution between the parties in South and North Korea. So that is 2000. And there is another agreement, those agreements on organization, operation of inter-Korean Commercial Arbitration Board. That was 2003. So the regime is already established, and in the Korean side, South Korean side, we already established the group within the KCAB. So we are waiting for the response from North Korean side. As for the procedural rules, UNCITRAL arbitration rule was adopted main reference for procedural rules to be agreed between Korea and North Korea. And particularly North Korea recently adopted CISG. So with CISG, with this arbitration regime, then we can effectively resolve the commercial dispute between North Korean companies, South Korean companies in the sale of the purchase of the goods. And there is a separate industrial area called the Kaesong Industrial Complex. We call the Kaesong Industrial Zone, Economic Zone. We have recently had some difficulties, but in 2013, that Kaesong Industrial Complex also have Inter-Korean Joint Committee. They signed actually implementation of agreements of Korean commercial arbitration board for Kaesong Industrial Complex. So again, the arbitration became the main tool to resolve dispute between North and South Korea. All right. So Korea seems to caught world attention for many reasons in recent years. K-pop, K-drama, K-technology, K-cosmetic, and you can see the Squid Game is now quite popular around the world, and everybody talking about Squid Game. So Korea, what's happening here is that is not real Korean. You say Korean, K-pop is not the Korean music. It's just the music of all different cultures. K-drama is, of course, we are talking about Korean life, but not traditional Korean things. It's something like we just take ideas from all around the world. Same applies to Squid Game. The game they are playing there is the game I played when I was very young. But the drama itself is very modern. It's just international. So that is what we call K something. We do not insist just a Korean traditional thing should be the standard. We say international things, Korea adopted and then make it, and they found that it's international, became international again with the name of the K something. So we put the in the same way, K arbitration, that has a similar ring to popular siblings that fast catching up. So the K arbitration means not a particular arbitration from Korea. We say good practice, good arbitration practice, best arbitration practice we can use in other countries. We call the K arbitration. Recently, I introduced the Gangnam arbitration because actually I found that the Gangnam is better known than Seoul. So Gangnam arbitration is just like we have more hearings for to encourage tribunal engaged in the process in early stage, and then have some ideas of the witness conferencing or more effective way to document production. All those ideas, not necessarily coming from Korea, but we adopted such an ideas from all different jurisdictions, and just summarize and establish that, try to establish that it should be used as international in international arbitration society. That is our hope. So in conclusion, it must take away from Korea's example and emerged of key international arbitration player, and this important thing is there is a cohesive effort by all stakeholders to promote international arbitration and emerging regime. So that includes the Arbitration Council, parties, arbitrators, judiciary, government, arbitral institutions, we actually all work together to promote international arbitration. They make international arbitration successful in Korea. So any emerging regional regime will have to tackle the work of each of their rebels simultaneously. So imagine the ecosystem like the chariot, where each of wheels have to function independently and together at the same time. So any effort to strengthen one limb while the other limb suffers will only lead to stagnation of arbitral regime. That was a brief overview of the growth of the Korean arbitration industry and the lessons from it that can be implementing an emerging arbitration jurisdiction. I'm happy to answer any questions if there are any, and I'm grateful again for inviting me to speak at this platform on this topic. Thank you very much.
Thank you, Kevin, for your enlightening lecture. We also have the presence of our Honorable Vice Chancellor who could not join us early because of the traffic. Sir, before we take questions and answers, would you like to uh, give some comments? Sir, please unmute yourself.
Yeah,
Yes, sir.
thank you, Chirag. Our today chief guest, Mr. Kim Kevin, the senior partner in the Korean law firm, my colleague and coordinator of Center of Arbitration and Research, Maharashtra National Law University, Mumbai, other colleagues, and dear participants. It has been indeed really a great pleasure to listen to Mr. Kevin, Mr. Kim, on such a finer points of the arbitration and particularly the Korean experience. I apologize for little more delay because of the traffic. In Mumbai, traffic is so much moreover after a week holidays. I do not know whether it has been pointed out that the National Law University here in Mumbai was established 6 years before. This is now 7th year, wherein you offer BA LLB honors 5 years degree course as well as 1 year LLM regular course having specialization in multiple disciplines including maritime law, and along with that we have other courses like particularly the postgraduate degree MA in mediation and conflict resolution, which was introduced last year. This is the second year, wherein we had received the overwhelming response in both these years. Along with this, we have 14 centers like Center of Maritime Law and Research, Center of Mediation and Research, and Center of Arbitration and Research in Maharashtra National Law University, Mumbai. Our aim or the goal is not only to impart the legal education, but at the same time to contribute into the current, recent, and required needs and demands of the changing time. At the outset, I welcome, though his lecture is over, Mr. Kim, and thank him on my behalf and on behalf of the Maharashtra National Law University, Mumbai, for having accepted our invitation and graced the occasion and enlightened all of us on such an important theme. As Mr. Kim has pointed out, I could listen few things hardly that the Korean experience or Korean model, if at all it is permissible to call it, whether we also can adopt that model vis-a-vis arbitration is concerned. Rather, we are coming up now on about the conference of arbitration, international conference on arbitration in energy laws in the next month itself. And today, as we do understand and realize everywhere around the globe, just a week or so before the conference on environmental and climate change, which has happened, conducted international conference at Glasgow, Sweden, wherein the issue about net zero and carbon, which has come up. Rather, there is a divide between developed and developing countries. Developing countries' point of view is that it is the developed countries' responsibility to contribute into the climate change fund or environmental fund, whereas developing countries have certain different kind of point of view. From this perspective, every country needs the energy. So instead of the traditional orthodox ways of generating energy like the thermal powers, to switch over to the green energy, and from that point of view, even the issues of and conflicts of interest which are going to be occurred and which are occurring also, to address those conflicts and international conflicts also, to address that or to review that, we have decided to organize the international conference on arbitration vis-a-vis the energy laws as such. So the aim is not only to impart the legal education, but at the same time to tap and tackle such issues wherein we can contribute in some way with the great help, support, and affinity of people like Mr. Kim, so that the not only participants, not only India as well as Korea or other countries will benefit, the whole world could be benefited out of it. From this perspective, from this point of view, the today's program and Mr. Kim's enlightening speech is really very, very useful, very, very beneficial to all of us. So with this, I thank once again Mr. Kim Kevin for enlightening us, and hope that in future too we'll have kind of a not only cooperation, kind of a personal bond with at institutional level as well as at personal level. With this, I thank once again to him as well as all of you. Thank you so much.
Thank you, sir. It really means a lot that you could share the time and could personally come and welcome our guest. It's very important that how each small thing we do, we contextualize in the broader context of how the globe is shaping, how the environment is shaping. And in fact, you have very rightfully pointed out, in the sphere of arbitration, environment is becoming one of the major concerns. And how an arbitration which is meant to be confidential, which is meant to be a private affair, such environmental issues can also be pitched in. We are going to see that in the near future. Thank you for bringing that out. Uh, Kevin, now, if you permit, we would like to move to the question and answers. Myself, I have plenty of questions from your presentation. I would like to understand the Korean law better. But before that, let me give an opportunity to our participants here today. Uh, so, if anyone has any question, please either put it in the chat box or you can raise your hand. And before we get the questions, so let me put one question to you, Kevin. So you talked about earlier that in Korea, Korean courts have never refused enforcement. So what are the reasons? Is it because the awards are very well drafted? Is it because of the pro enforcement bias which is utilized? Or what is the reason? Not a single award which could be questioned on the ground of propriety. Can you elaborate more on that?
Oh yeah, that is quite good question. Um, and I say, arbitration. Many people ask me, why we Korean companies have many arbitration. Um, I think of course the Korean companies have a lot of international transaction. But in addition to that, the uh, Korean companies are a bit different from Japanese companies. They're willing to fight if there's good reason. So the cases Korean companies involved normally very serious. If they don't have good defense, they don't have arbitration. They just agree to settle. But when they have good reason, they fight. But the normally they nominate quite well-known arbitrators. They normally agree to very well-known international arbitration institutions. So arbitral word to be enforced in Korea, mostly from ICC, LCIA, CRH, KIC, and is normally handled by very well reputable arbitrators. I don't check every case, but as far as I understand, the case that we went to the enforcement procedure, it's all serious cases.
Right.
The normal cases actually they settle in the middle, or the Korean parties voluntarily and perform the obligation under the arbitral word. And the Korean court have very strong feeling that the court shall not interfere with arbitral word. So there is some case where the Korean court handle jurisdiction issues as court case, meaning that you have arbitration agreement. One party say, "Oh, we don't have arbitration agreement. We pursue litigation." Then Korean court reviewed the case. They found that okay, they have jurisdiction over the case. They proceed. There is some occasion like that, but once the tribunal issued the word, then Korean court, particularly Korean Supreme Court, really try to respect the arbitral word enforced as is. So unless we have problem with the arbitration agreement or some significant issues, but as the public policy or the other procedural issues, some issues and the opportunity to present the case, all Korean court all rejected their challenge. So far, arbitration agreement wise, there is not many cases. Actually, I understand there are 2-3 cases. Again, the Supreme Court respect the tribunal's decision. Just say, okay, we agree with the tribunal that this arbitration will exist. So that is the background. Maybe in the I know. I think it's not right. The Korean court blindly enforce all the arbitral word. So maybe someday we will have some case where the Korean court refused to enforce arbitral word because there is no arbitration agreement. But so far, we have Korean court have maintained clean record.
So there is a similar question from the participant. So the add-on is whether any modification has been made as compared to the model law, which has resulted into this efficacy or pro-enforcement bias, or is it very similar to the model law? The question is more about setting aside provision. rather than New York Convention.
Yeah, our Arbitration Act is almost same as just translation of the UNCITRAL model law.
Yes.
We just take word to word.
Right.
And because actually normally the Korean legal system is just say, okay, for example, we have New York Convention. So New York Convention applied to Korean as a matter of Korean law. We do not make any separate law to enforce the New York Convention. We just use the New York Convention as is. Same applied to CISG. So CISG, we use the CISG wordings rather than making separate enactment. In case of Arbitration Act, because UNCITRAL model law have several options, so we take the option, but we never modify the contents of the UNCITRAL model law. That is quite general attitude of Korean society, because we are educated. Just say we are the small country and we have to do international transaction. We should be international. We're quite obsessed the idea that we should be international and neutral. So that is why you see that other K-drama, K-pop, we never insist that our traditional thing should prevail or that this should be the right way to do that. We never thought such a thing. So when you adopt the arbitration law, we try to adopt what is the most internationally acceptable standard. So once we found that there's international acceptable standard, we never hesitate to take it as our things. So that is why we actually adopted UNCITRAL model law 5 years earlier than Japan. And we also adopted the revised UNCITRAL model law in 2016 for the first time among the East Asian countries. That also shows that the Korean society as a whole willing to take international standard.
Whether arbitration is preferred more than mediation?
Mediation is separating, recently, particularly recent 2 years, when you have a Singapore convention, mediation became big issue in Korea. So again, because we found that mediation became international trend. So when I meet the client nowadays, the client always asks me about mediation. So that never happens before. But arbitration is still the parties agree to arbitrate in the contract. But before the arbitration or in the middle of arbitration, I see many occasions the Korean parties looking. They are looking for mediation opportunity. So I have some case where we mediate before the arbitration. We failed to agree, then arbitration started. And then sometime later, parties settled the case. Based upon discussion, they had the mediation before the arbitration. And we have another case where the arbitration case was bifurcated and the tribunal decided on the liability. So before the case moved to the quantum, parties mediated in London. Just 2 days, we settled the case. So the mediation became quite popular issue nowadays in Korea.
Whether such mediation is part of an arbitration clause?
Not that way, actually. Of course, there's some case where there's mediation became arbitration, but normally the contract itself has only arbitration clause. Because adjudication is not popular in Korea at all. In some jurisdictions, adjudication is quite popular, but in Korea, when you have dispute, we go to arbitration. But party voluntarily agree to mediation. So far, the mandatory mediation is not that popular yet, because sometimes you just see the delay of the arbitration process and you have mandatory mediation clause. I have one case where recently there is a mediation clause, mandatory mediation clause in arbitration clause. So mediation just lasts for 6 months. Parties waiting just 6 months without no result, but that's a mandatory mediation clause for 6 months.
Right. In your presentation, you mentioned about high internet speed in Korea and virtual hearing. So, question is, what if one of the party objects to the virtual hearing? Will the arbitrator still proceed in Korea?
In Korea, yes. I understand that ICC, when I was at ICC court actually reviewed that issue, and then we finally declared that under the ICC rules, arbitration tribunal can proceed arbitration virtually. But there is some issue, depending upon which institution you're dealing with. But in Korea, there's no restriction, and because at board meetings and other all important meetings are conducted in Korea virtually, even before this COVID-19 situation. And we have court, you can attend the court virtually. We use the court virtual system, in a court, because when the party is located in Ireland, they cannot travel, then the judge just see the party through video. That happens before virtual hearing. So in Korea, the virtual hearing itself, you don't have issue to admit that that is the hearing as defined as hearing, unless the institution rule specifically require the physical hearing rather than virtual hearing.
Thank you. Earlier, you mentioned in your presentation about involvement of practitioners from India, Pakistan in your law firm. We do not see much of that in India or in Indian law firms. So, does this diversity of practitioner in a law firm offers any kind of advantages in terms of growth of arbitration?
Yes, because international arbitration, when you have, even Indian parties have arbitration, you naturally have the opposing side from different countries, right? They could be Korean, it could be Japanese, Chinese. So when you have different lawyers from different jurisdiction, for example, when you have, my colleagues at the Indian lawyers, we don't expect any Indian related case. We just hire them because they're good lawyers.
Right.
They speak good English. They are well educated, experienced in international arbitration. So we work together, and then they are learning the Asian practice. So involving Korean, Japan, China, Singapore, Hong Kong, such a practice. So we learn together as one group. I had the previous colleagues. When I established this law firm, one of my first colleague was he was from Pakistan. He's now into the MBA program in America. Very internationalized person. So, and we have the lawyer from Singapore. Again, we never actually rely on Singapore law specific advice from that lawyer. We just work together dealing with that issue. So Singapore lawyer is a common law lawyer. We exchange ideas, how we see that issues as a civil lawyer and a common law lawyer. And Singapore lawyers can read Chinese characters. We can read Chinese characters. We have some common things. while we have an American lawyer or Australian lawyer, totally different view, right? Have no idea about Chinese characters, and they never understand, some Asian settings, why the age is so important, for example. So that, because international dispute, you have to deal with those issues together. That is the beauty of international arbitration. So it's always useful when you have the members from different jurisdiction and they understand of different culture, different background, and the language. Language is another big issue. We actually, Peter and Kim, we can cover like 17 different languages within our firm, right? But particularly in Asia, the language really matters, and together with the governing law. So that I think it's very useful when you have lawyers from all different countries.
So I'll just ask one last question on the aspect of language and our young candidates' prospect of working with Peter and Kim. So whether proficiency of English is enough or whether some kind of acquaintance with Korean is also required.
No Indian lawyers in our firm speak Korean. Yeah, English is good enough. You don't have to speak. It's actually, we support them to learn Korean.
Okay.
Because now learning Korean is useful. See the Korean dramas and Korean songs, but we don't require the our foreign lawyers. We have Singapore lawyer, French lawyer. They never speak Korean. It doesn't matter actually. English is good enough.
Can you register to a Korean bar without the language requirement?
Korean bar, no, you have to pass the Korean bar exam, which
Okay.
is in Korean.
Right.
But as foreign legal consultant, you still can register your qualification in Korea. And then if you're working for the Korean law firm, you don't have to register as foreign legal consultant in Korea. As working for the international law firm, you have to register as foreign legal consultant. But if you work for the Korean law firm,
Right.
you just work for the Korean law firm without such a qualification.
Correct. So I think we still have questions coming up, but I think for the sake of time, we should stop. I personally enjoyed the session a lot. It was an excellent session with beautiful pictures from Korea. So it served two purposes, knowledge as well as it was a kind of trip to Korea. I saw the infrastructure, it's so beautiful. Maybe in future, some of us who is attending this session today would love to visit Korea and see the development firsthand. Thank you so much, Kevin. It was a big pleasure to have you here giving this distinguished lecture. We are truly honored. Thank you so much.
Thank you very much. Thank you for inviting me. Bye.
Yeah.